Good morning, everyone, and thank you for joining us. My name is Priya Saran, and I'm here today with my colleague, Chris West. We have roughly 2,500 people registered for today's webinar, which really speaks to the importance of this topic. The format for this morning is as follows. For approximately the next hour, myself and Chris will present on this topic, mental illness and substance use in the workplace, and then we'll leave approximately 30 minutes for questions at the end. So if you have a question for us, please type it into the Q&A box on your screen, not the chat box, which should be disabled, and we'll do our best to answer as many questions as possible. If we don't get to your question, please reach out to us after the presentation and we'll get back to you then. Finally, a recording of this presentation and a copy of the slide deck will be on our website in a day or two. So with that, let's get started. For this morning's agenda, I will be taking you through the first two topics. First, we'll look at how to handle the situation where you suspect that an employee has a substance use disorder and what we refer to as the employer's duty to inquire. Then we'll review the employer's rights and obligations when it comes to accommodating a mental disability, including looking at some accommodation strategies. Then I'll be turning it over to my colleague, Chris, who will take you through the types of claims that employees can make to WSIB related to mental illness. And finally, he will outline the circumstances in which you can terminate or discipline an employee who has a mental illness. So let's start by looking at why this topic is important. Human rights legislation across Canada recognizes mental illness as a form of disability. And alcoholism and drug addiction are accepted examples of mental illness. More than that, however, mental illness is one of the leading causes of disability in Canada. And here's some interesting statistics that you might want to consider. So in 2021, Statistics Canada reported that 8.7% of the Canadian workforce had a mental disability. And even more staggering, the Canadian Mental Health Association reported that by the age of 40, about 50% of the population will have or have had a mental illness. So despite its prevalence, employers may have a more challenging time addressing mental disabilities in the workplace for a couple of reasons. First, employees might not be aware of their disability. They might not have been diagnosed yet. The employee might not disclose the disability to you in a clear way. They might mention it in passing or only allude to it. Third, an employee might be afraid to disclose their mental disability due to stigma or fear of damage to their reputation. And this is probably the most common issue. And in fact, a poll that was done by Ipsos in 2019 concluded that less than 25% reported feeling comfortable telling their employer that they had a mental disability. But even if an employee doesn't come to you and disclose that they have a mental disability, you may still have a duty to inquire about the possibility of it. So when is the duty to inquire triggered? The duty to inquire will be triggered when there is a basis to believe that their behavior or their performance might be related to the disability. And this will usually happen where an employee engages in conduct that is out of character. For example, a normally quiet person starts having sudden outbursts of anger. Maybe you find bottles in their desk and they're impaired at work, or maybe they vaguely mention something in passing about their health. What's important for you to know as an employer is that the failure to meet the duty to inquire can lead to a breach of the duty to accommodate. The duty to inquire was recently discussed in a case called Calkins versus Broadview Homes. This case was about a short service employee who about a year after they started working, the employer saw a change in their behavior and they started getting a lot of customer complaints. At this time, when they broached the subject with the employee disclosed to his supervisor that he thought he had a brain injury and needed to see a doctor. What he referred to was something called CTE. The supervisor forgot about the conversation and didn't really understand what CTE was. So after another complaint, the employer decided to terminate the employee's employment. Unsurprisingly, the individual brought a complaint to the Human Rights Tribunal, and the tribunal agreed that the employer had engaged in discrimination because they failed to consider the possibility that the performance issues and behavior were related to the disability. And as it turned out, the individual did have a disability, and the termination was held to be discriminatory. So the duty to inquire commonly arises where there is suspected workplace impairment. This happens often in the substance use context. The conduct would normally be considered culpable coming to work impaired, but the duty to inquire may first require a discussion with the employee to determine if their behavior is related to a substance use disorder. So if the behavior is related to an addiction or a substance use disorder, then you may have a duty to accommodate them. If they don't have a substance use disorder, then disciplinary response may be appropriate. So what do you do if someone comes to work impaired? One of your employees is visibly impaired. First, you're going to want to document the conduct and symptoms, and if possible, have another employee independently verify what you've seen. And this is because we need to have some evidence in case disciplinary consequences follow. So you'll want documentation and another witness to record what they saw. If you're in a workplace where you have a policy that permits you to conduct drug and alcohol tests, you'll then want to do the drug and alcohol test. In all circumstances, you're going to send the employee home in a taxi so that you know they get home safely, and you'll instruct them to call you the next day. Before they come back to work, you'll speak to the employee about what you saw and your assessment that they were impaired at work. And if you did a drug and alcohol test, you'll provide them with the results of the drug and alcohol test. Then you're going to give the employee an opportunity to respond and explain their behavior. It is appropriate, and you should ask whether or not their behavior was related to a substance use disorder. If they say no, you can treat their breach of policy as culpable or serious misconduct. And if not, if the employee discloses that they may have a substance use disorder, now we're into the next stage of this process. So we're going to request that they go see their doctor and provide you with medical documentation to confirm their diagnosis of a substance use disorder or a disability. And you're going to request a copy of their treatment plan. The treatment plan could range from things like counseling to inpatient rehabilitation, attending support and recovery groups. From your perspective, the focus should be on accommodating the employee in such a way that they will be able to return to work free from any form of impairment. And we'll understand that whatever accommodation you provide is going to be very much dependent on the assessment that we get from the physician and whether or not the work they do is safety sensitive. So it may not be possible for them to be accommodated in the workplace until they've completed an inpatient rehab program, depending on the severity of the addiction. Okay, so let's move on and talk about accommodating mental disabilities. Starting point to ask is, what is a mental disability? So a mental disability can include a mental impairment, a learning disability, or a mental disorder. What's important to note is that mental health is distinguishable from mental disabilities. Mental health is the state of your psychological and emotional well-being. It's your ability to cope with normal life stresses. So your normal personal characteristics or normal ailments, like getting the flu, these are not typically considered to be a disability. Similarly, the normal response that you might have to suffering a loss, like the death of a loved one, or a personal failure, the stress and anxiety that's associated with that, that is not a disability. A mental disorder is characterized, and I will give you a technical definition, by a clinically significant disturbance in an individual's cognition, emotional regulation, or behavior. And it's usually associated with distress or impairment in important areas of mental functioning, which substantially interfere with your major life activities. Okay, so an interesting case that really highlights and underscores this point is a case called SkyTrain versus CUPE Local 7000. This case addressed the fact that mere anxiety and stress is not going to meet the threshold for a mental disability, but also it highlighted that there needs to be medical evidence of a disability for the duty to accommodate to be triggered. So in this case, an employee was dismissed because of excessive absenteeism. The employee and the union alleged that the dismissal was discriminatory and that the employer had failed to accommodate the employee's mental disability. But the medical that was provided to the employer never clearly indicated that the individual had a disability. They sort of danced around it and made references to stress and being depressed, but never indicated that there had been a diagnosis of a disability. Similarly, in an Ontario case at the Human Rights Tribunal, we saw again the distinction and the importance given to the medical documentation and the diagnosis of a disability. So in this case, an employee was harassed and stalked by a customer at work, and they requested a permanent transfer from Toronto to Collingwood. The employer granted a temporary transfer to the employee on a compassionate basis, but didn't grant the transfer on a permanent basis. The employee alleged that this was discrimination and that the transfer was necessary to accommodate their mental disability. Notably, the medical note that was provided to the employer only recommended that the employee be relocated, but did not mention a disability. So the employee then filed a claim with the Human Rights Tribunal and alleged discrimination. The application was dismissed because the tribunal examined the medical documentations, and what they had was a self-report from the individual referring to stress, health problems, and mental anguish. And the employer had a doctor's note, which, as I mentioned earlier, recommends relocation, but does not mention disability. At the hearing itself, there was medical documentation that was submitted. There was a physician's letter and a psychologist's letter, which did indicate that the employee meets the definition or had a generalized anxiety disorder. But this documentation had not been provided to the employer at the time that the accommodation was requested. So the application was dismissed, and ultimately what this case highlights for us is that an employee needs to be diagnosed with a disability before the duty to accommodate is engaged. So that brings us to the next question, which is, what kind of medical documentation can I ask for, and what should I be expecting to receive? So first point here is the employer has the right to sufficient medical information to support the assertion that the employee has a disability and that they require an accommodation. If you get a vague or unhelpful one-line doctor's note, which many of us do, you do have the right to request further and better documentation from their medical provider. If you aren't getting the answers that you need, or you're unsuccessful getting the information you need from their doctor, you might consider getting sending the employee for an independent medical examination or a third-party medical review. So here's what you're entitled to with respect to medical documentation. You're entitled to confirmation that the employee has a disability, You're entitled to information about the nature of the illness. And in some cases, that might mean diagnosis when we're talking about substance use disorder. But with respect to the nature of the illness, we need to know this because it's very difficult to engage in the accommodation process if we don't know what type of issue we're dealing with, if it's psychological or if it's physical. We're also entitled to know whether the disability is temporary or permanent, how long it's anticipated that it's going to take for the employee to improve, what their functional limitations and restrictions are. We're entitled to know how the medical conclusion was reached and to have information about the treatment plan. And this is particularly irrelevant in the case of substance use disorders. And, we may come back to this later, but, if you think about it, if an employee is not attending their counseling meetings or they haven't completed the rehabilitation program, that's going to have consequences for how the employer handles the situation if there's a relapse. Finally, an employer can ask for a medical opinion as to whether an employee can perform a particular task, but we don't have to follow the physician's determination or recommendation for what specific role the employee can perform. That's management's right and responsibility to determine based on the limitations that are provided to us. So the employee also has a duty to participate and to cooperate in the accommodation process. They have an obligation to provide you with sufficient medical documentation that will confirm they have a disability, substantiate their need for accommodation, and give you enough information to determine what that accommodation should look like. And they should be providing you with sufficient information on their prognosis and the improvement of their stated limitations. So particularly in cases of mental disability or substance use disorder, as I mentioned earlier, employees can be very reluctant to disclose this type of information. But what's really important to note here is that if they fail to provide you with sufficient medical documentation and to participate in good faith in the accommodation process, that can bring the accommodation duty to an end and you will have satisfied your obligations. So this is like, for example, what happened in the LCBO case. A way of dealing with an employee's reluctance to disclose medical information can be through the implementation of policies which clearly indicate the supports that will be provided to an employee if they come forward in good faith and disclose that they have an addiction or a substance use disorder. So the consequences of an employee's failure to cooperate in the accommodation process were highlighted in a case called Interim Place versus OPSEU. It's a relatively recent decision from 2020. And this case involved an employee who was a community outreach and support counselor and who, after a period of disability, wanted to work a 3-day work week. But the medical documentation that the employee provided to the employer never confirmed that this request for a shortened work week was related to their disability. So there was a whole lot of back and forth between the employer and the employee trying to get the medical documentation that they needed to substantiate the disability and the restrictions and limitations. The physician largely opined on the employee's role and schedule, but never related it to the disability. And interestingly, the employee refused to consent to the release of the medical information that the employer needed to support the leave. So ultimately, the employer determined that the individual's leave from work was unauthorized and warned them that if they didn't provide the information, the employee was going to be terminated. So the information was never provided, the individual was terminated, and the union grieved the dismissal. The grievance was dismissed because of that failure to share information and to participate and cooperate in the accommodation process. The The arbitrator in that case held that the employer had fulfilled its duty to inquire. It made multiple attempts to obtain the necessary information, and that termination was appropriate in the circumstances. So if we meet our obligations as an employer and we ask the right questions, we give the employee a reasonable opportunity to provide what we need, termination will be appropriate. Okay. So once we've met the duty to inquire and we've confirmed the existence of a disability, now what? Well, now we get into the accommodation process itself. The employer has a duty to accommodate medical restrictions and limitations to the point of undue hardship. And employers often ask, well, what does that mean? Undue hardship is a very high threshold to meet. You may consider factors like the financial cost, health and safety, the size of an organization, the nature of an employee's position, and the impact on other coworkers when engaging in an accommodation. But ultimately, you will be expected to suffer some inconvenience and to make substantial efforts to reach that threshold. So the accommodation itself, reaching the appropriate accommodation may require some flexibility and creativity. And we keep in mind that if the individual cannot be accommodated in the workplace because of their restrictions, a leave of absence may be appropriate. Accommodating mental disabilities can be particularly challenging, though, because the restrictions are often cognitive, psychological, or behavioral. Sometimes they're difficult to specify or define. We don't know always when they're going to be triggered. They can be dynamic and unpredictable, and they can be impacted by both factors in the workplace and outside of the workplace. So that means we need to have a whole basket full of potential strategies that we can use to accommodate an employee. So some examples. We might modify an individual's job duties. That could include, for example, job sharing arrangements, exchanging minor tasks between different employees. It could involve adjusting an employee's scheduling, flexible hours, maybe using part-time shifts, allowing the employee frequent or timed breaks, short or long-term leaves of absence in the case where there isn't an accommodation in the workplace that will be sufficient. Or simply providing the employee with time off for medical appointments and for treatment. Other forms of accommodation that could be appropriate are adjusting training. So for example, we might give someone extra time to train. We might provide them with additional resources, or we may customize and individualize the training to that person. Other things that we might think about are adjusting the way in which we supervise or manage the employees. So do we change the method of communication? Is it better if I communicate in writing primarily because the individual isn't able to retain verbal instructions on the fly? Or do we have verbal check-ins or job coaching meetings on a week-by-week basis? And lastly, we may consider altering the work environment. So if focus and concentration is an issue, we provide them with a quieter workspace in a more secluded environment, or maybe other tools of the job that may facilitate the ability to perform effectively. What's really important to keep in mind, though, with substance use disorders and under other types of mental health or mental illnesses, is that we need to plan for relapses and setbacks. We don't just get better instantaneously because I've had, a treatment. And this is something that we can expect to happen, so we should plan for it. An employee may be absent from time to time because of their disability. So consider in advance how you're going to handle this situation. What happens if there are changes to an employee's restrictions or prognosis? How are we going to handle conflicts that arise in relation to the disability, as between coworkers, for example? How will we manage if an employee's performance suddenly starts to decline? And what are we going to tell managers and coworkers about the situation when it arises. Some final thoughts before I turn the reins over to my colleague. Employers have a duty to provide reasonable accommodations, not perfect accommodations. An employee is not entitled to their preferred form of accommodation. It just has to be reasonable, and it can you can keep in mind what the business's needs are. On the flip side, an employee has a corresponding duty to accept a reasonable accommodation, even if it isn't exactly what they wanted. If an employee doesn't accept a reasonable accommodation, that may end your duties to accommodate. And with that, I will turn it over to my colleague, Chris, to talk to you about WSIB stress claims.
Okay, thank you, Priya. Priya is always a very difficult act to follow, but I'm going to do my very, very best. Thank you again for all joining us this morning. I'll dive right into what I'm talking about. As Priya said, WSIB stress claims. So the WSIB, of course, stands for the Workplace Safety Insurance Board. And WSIB claims deal with workplace-related injuries. And often when we think about WSIB claims, we think about physical injuries. But in certain cases, the WSIB does permit employees to make a WSIB injury claim in relation to a mental stress injury. I'm sure many of you have dealt with accommodation on the basis of mental illness disability, and we just heard Priya describe various accommodation considerations. When an employee is unable to work due to a mental disability, they're often entitled to an unpaid leave of absence. And during that, they're going to apply for EI benefits or disability benefits like STD or LTD. But these categories of WSIB stress claims may actually entitle the employee to WSIB injury applications that are related specifically to workplace stress. Now, there's two categories of WSIB stress claim. The first is chronic mental stress. And this is a mental stress injury that can be shown to have resulted from a series of incidents at work that what the WSIB call substantial stressors. And a substantial stressor is stress at work that is excessive in intensity and duration. That comparison being made is it excessive in comparison to the normal pressures and tensions that are experienced by workers that are in similar circumstances. So to make a chronic mental stress claim to the WSIB, the worker has to be diagnosed, first of all, with a mental stress injury, and there must be a significant nexus or connection to the workplace. Also, the stress at work, the chronic stress at work, must be the predominant cause of the injury. So we're not talking about existing mental injuries that were brought into the workplace. Instead, it must be shown that the stress at work has actually caused the mental injury in order for it to be something that the WSIB will consider. Some examples of chronic mental stress claims might be in the context of an employee who's been experiencing ongoing workplace harassment, or from an employee in an occupation which by necessity places them in situations where there's high degrees of routine stress. Examples of some occupations where we might see a chronic mental stress injury are employees who work in emergency services, for example, or are working in matters of life and death, or are in dangerous occupations. Where a worker is not entitled to WSIB benefits is for stress caused by things that are typical in any workplace. So for example, performance reviews, or receiving discipline, or having to give a presentation over Zoom to thousands of people on a Wednesday morning. These are not the type of normal workplace stresses that would justify a WSIB mental stress claim. Also, interpersonal conflicts between workers and their supervisors, with their coworkers or customers, these are considered to be a typical feature of normal employment. So unless that conflict amounts to workplace harassment, or the conduct is something that a reasonable person would perceive as egregious or abusive, we're not getting to the level of what the WSIB would consider in a chronic mental stress claim. The other category of WSIB stress claim are what are known as traumatic mental stress injuries. And unlike chronic stress, this is a category that relates to one or a few distinct traumatic events that have caused or significantly contributed to a diagnosed mental stress injury. So once again, the injury must be properly diagnosed, and it has to be sufficiently connected to the workplace. Some examples of what might justify a traumatic mental stress claim is where a worker is subjected to physical violence, or they've witnessed a violent crime at work, or they witnessed a very serious workplace accident. And what the WSIB is doing is they're determining whether something is sufficiently traumatic to justify this claim, based on whether or not the event in question, the traumatic event in question, is objectively traumatic. So would a reasonable person view the event as being one that goes beyond what one would reasonably expect to see in the workplace? So once again, an employee's managerial discretion, for example, in discipline or termination or changing someone's workplace duties, these are all regular things in the workplace, and they're not going to give rise to the level of a traumatic event unless they're particularly egregious or abusive. So what are some practical tips? Like with any WSIB claim, as an employer, you want to be satisfied that what has actually caused the injury is sufficiently connected to the workplace. So if you have any doubts about whether a chronic or a traumatic stress injury was actually caused in or by the workplace, then reach out to someone at SK and discuss how to effectively dispute that WSIB claim. Also, as with any workplace injury, a workplace investigation can be a very useful tool to support your position concerning a workplace injury. And while the investigation is not determinative, the WSIB will consider the findings of a properly conducted investigation, and that's going to assist them in determining whether there is a sufficient nexus between the alleged injury and the workplace. And that's really the connection that the WSIB is looking for. As demonstrated by this excellent clip art, I'm next going to be talking about discipline and termination in the context of mental health and substance use in the workplace. As we know, discipline is an appropriate response if it's determined that an employee has knowingly engaged in inappropriate or damaging conduct at the workplace. We're thinking of things like theft, harassment, unexplained absences. Those are all justifiable reasons to discipline an employee. But in the context of mental health and substance use disabilities, there can be a bit of a blurring of the lines. And that's because these types of disabilities could actually be the driving cause of the employee's misconduct. So in other words, if the employee's improper conduct can be shown as directly linked and caused by the disability itself, the employee might not be held fully responsible for their behavior. The important question to always consider is whether the conduct is within the employee's ability to control and change. And that can be a very difficult thing to determine. If you find yourself in a situation where you notice a sudden shift in an employee's demeanor, or perhaps you find evidence that might suggest a substance use disability, that could point to the cause of the misconduct being tied to a mental health or addiction disability. And as such, it gives rise to the potential that the employee's misconduct is non-culpable. So the existence and the severity of the disability itself may demonstrate that the employee is not in full control of their actions. It's the disability or the addiction that actually is. So it's important to remember that that's not always going to be clear. It's not always going to be obvious that the employee's misconduct is attributable to a disability. And if you have an employee who suggest to you that their conduct is caused by a disability, remember that it's their onus to prove that with supporting medical evidence. We can take a look at some cases where discipline was applied in situations that related to a substance-related disability. The first case we'll look at is Cambridge Memorial Hospital and the Ontario Nurses Association. This is from 2017. And in this case, a nurse was stealing painkillers that were prescribed for patients, and she falsified medical records to assist with that theft. What the nurse was actually doing in this case was taking a look at patient records, seeing who was prescribed painkillers, then going to the medication storeroom to get the prescription, and she'd give half of the prescription to the patient and keep the other half for herself. Now, that's obviously very serious misconduct. It's also very dangerous in the context of a patient who's been prescribed medication. So having discovered the misconduct, the employer terminated the nurse for cause. After the termination, the employee and her union alleged that the employee was addicted to the painkillers. And so the severity of that addiction was the thing that was actually driving this misconduct. The employer took the opposite position and suggested the evidence only showed that the level of addiction was not as severe as was being alleged by the employee. So, for example, the employee didn't fully own up to their misconduct. They didn't use the painkillers while at work. And the employee also gave evidence that they didn't use painkillers, for example, when they were on vacation. An important factor in any just cause dismissal is going to be a consideration of the post-dismissal conduct. And the decision maker is going to use that to determine whether or not it might be appropriate for the employee to return to work without the risk of further misconduct. And in this case, the arbitrator did consider the fact that the employee had demonstrated a commitment to rehab. And there was supporting evidence from a doctor that the risk of the employee's relapse, if they returned to work, was quite low. But the arbitrator in this case nonetheless upheld the termination on the basis that the evidence did not support the severity of the employee's addiction, or that it was sufficient, that the severity of the addiction was sufficient to determine the employee was not culpable for her own actions. So there's a quote that I think from this decision really helps illustrate how a decision maker might analyze whether or not an employee is culpable of their misconduct. So the arbitrator here said, "I have no doubt that the employee would not have conducted herself in the fashion she did, but for her drug dependence. Nor am I in a position to call into question the doctor's opinion that the griever was addicted and not merely a recreational user. But in my view, which is consistent with the doctor's evidence, there are degrees of addiction. The griever's addiction, based on her own evidence, was not compulsive. She did not use at work. She went on vacation for 1 or 2 weeks without using, and she suffered little to no withdrawal when she went off the painkillers." Now, I found that quote to be notable because it helps demonstrate why, in the second decision we're about to look at, the arbitrator came to the exact opposite conclusion. So this case is Regional Municipality of Waterloo, Regional Municipality of Waterloo and Sunnyside Home. And again, it's against the Ontario Nurses Association. This case is from 2019. So very similar facts. We've got a nurse that stole painkillers that were prescribed for patients, and she falsified medical records. The difference here was the level of addiction. So what the evidence showed is that the nurse had been caught using painkillers at work. She was coming into the hospital early to facilitate her theft. She was using a stronger painkiller than the nurse in the previous case. And the evidence showed that she was using painkillers every day just to get through the workday. Also notable is that the employee experienced significant withdrawals as part of her recovery process, which again points to a more serious addiction. So all of those factors considered together pointed to the addiction in this case being more severe than the addiction in the previous case. Now, once again, the decision maker considered the post-employment conduct of the employee as part of their analysis about whether reinstatement was possible. And again, the evidence here showed that there was significant progress. There was rehabilitation efforts and completion of programs. And there was a few medical experts that testified that they supported the employee's return to work. And based on this evidence and the evidence that supported the severity of the disability, the termination for cause in this case was overturned and the employee was actually reinstated. And I think the takeaway from these cases is that an invisible disability they're very hard to manage and understand. And in the context of an addiction disability, we just saw two decisions with similar facts lead to completely different conclusions, and it was based on the severity of the addiction. And that reinforces what I was talking about earlier, that the real analysis is whether the employee in question is culpable for their actions. Are they in control of what they're doing, or is the disability so severe that it's the driving factor in the employee's misconduct? So how do we mitigate risk? Once an employer either becomes aware that an employee has a mental health disability or a substance use disorder, an accommodation analysis has to take place. But as Priya discussed earlier, even if you have reason to suspect there may be a mental health disability or substance use disorder, you have the duty to inquire. And so how do you inquire? Well, you speak to the employee about their misconduct. And if a disability is alleged by the employee as justification for that misconduct, you're now entitled to seek medical documentation that supports the existence of the disability. And that documentation needs to not only support that a disability actually exists, but also how that disability is impacting the employee's behavior. So there has to be a nexus between the disability itself and the behavior that sufficiently explains the employee's misconduct. So let's say you've now received medical information supporting the existence of a substance use disorder, and you're in the accommodation phase. In the context of a substance use disorder, accommodation is further complicated by the fact that relapse is a recognized symptom of addiction. So taking an immediate all or nothing approach to accommodating a substance use disorder is often not appropriate. If a substance use disorder is established by the employee and you provide accommodation, for example, you've required that they enter treatment or undergo drug testing, a single breach of those requirements may not be considered sufficient to demonstrate that you as an employer have met the high undue hardship threshold that Priya was talking about earlier. So your accommodation process needs to take into account the potential for relapse, and it might require multiple attempts for the employee to try to return to work and engage in the requirements that you've set out for them. However, where attempts have been made to accommodate and those attempts have failed, the use of what we call a last chance agreement may become appropriate in the circumstances. And by definition, a last chance agreement implies that there have been numerous previous chances that have been provided to the employee. And if the accommodation isn't it's only when the initial attempts at accommodation are not working that a last chance agreement should be implemented. And what it really is an effective tool for the employer to document all the previous reasonable attempts that have been made to accommodate the substance use disorder, but also set out in black and white that this is the final opportunity for the employee to abide by the requirements set by the workplace. A last chance agreement is typically going to set out those conditions quite clearly, and there'll be things like abstaining from drug or alcohol use, whether at work or at home, participating in completing treatment, or taking drug tests in the workplace. What the terms will also say is that they'll have the employee and the union actually agree that any breach of this last chance agreement, any breach of those requirements that I just discussed, will constitute cause for dismissal. And they'll also constitute undue hardship for the employer. So the terms of this last chance agreement are abundantly clear that this is quite literally the last chance. Now, it's important to keep in mind that parties can never contract out of human rights legislation. So as we've discussed ad nauseum now, a substance use disability is a recognized disability protected by human rights legislation. So that still leaves the opportunity for an employee to say, post termination, that despite the fact I signed this last chance agreement, there's still a breach of human rights here. They still have the opportunity to try and do that. But again, what a last chance agreement is really doing is being used as an effective tool to document your accommodation attempts and demonstrate that the employee and the union understood the severity of the situation. And those things can go a very long way in assisting you as an employer in showing that you really have gotten to the end here. You've tried everything, and this really was a last chance. So putting a last chance agreement in real world context, we have a decision, Toronto District School Board and CUPE. This is from 2018. Here, a griever entered into a last chance agreement and breached the terms of it. The terms were that the griever enter into and complete alcohol treatment, a program, that they attend Alcoholics Anonymous on a daily basis, that they refrain from consuming any drugs or alcohol, and that they submit to urine or breathalyzer tests on a random basis once they were back at work. Now, for context, the employer in this case had previously given the employee, I believe it was 2 opportunities to attend and complete treatment. And both times the employee failed to do so. So as such, it was only at this stage that the employee and their union agreed to execute the last chance agreement. As part of the last chance agreement, like I said, they needed to provide proof of the completion of treatment, and which they failed to do. And once they failed to do that, the employer asked them to attend work and provide a urine sample, which again, the employee refused. So as a result, these were a breach of the terms of the last chance agreement, and the employee was terminated. Post-termination, the union provided evidence of the employee now engaging in and completing treatment, and evidence that essentially suggesting that the employee should be reinstated, regardless of the fact that this last chance agreement had been entered into and breached. But the arbitrator in this case determined that it should not second guess the terms of the last chance agreement. And as such, they dismissed the grievance and upheld the termination. The arbitrator found the employer in this case had demonstrated it met the threshold of undue hardship, and that the termination was therefore justified. And they have a quote that I think is helpful in that relates to the utility of a last chance agreement. So we can really see how, on a practical basis, how this thing can be an effective tool in the workplace. So the arbitrator said, "It has long been accepted that a last chance agreement is a useful device that allows an employer to drive home to an employee with addiction or attendance issues the seriousness of the situation without first resorting to the termination." In this case, the griever was already accommodated to the point of undue hardship, but still breached the last chance agreement in a number of significant ways. She carried on as if the last chance agreement did not exist. She continued to consume alcohol. She did not submit to an assessment by a professional. She did not complete a treatment program. And she was resistant to the random drug and alcohol testing to which she had already agreed in the last chance agreement. So it was not until after she had been terminated that she commenced to make some effort. And I think the takeaway here is that demonstrating undue hardship in the context of substance abuse, while difficult, is possible. The employer must take steps to attempt to accommodate. And the hope, of course, is always that the employee is going to make a full recovery. But if they don't, and attempts have been made to give them the opportunity to, there are still steps and tools that an employer can use, like a last chance agreement, that will support a finding of undue hardship or support a termination for cause. So in summary, a last chance agreement really is a last resort, and it's not going to be appropriate to implement on a first accommodation attempt. But if properly drafted and implemented, the last chance agreement can be an effective tool. And we've got lots of experience here at SK in drafting and implementing these last chance agreements and giving advice about it. So if you think it might be appropriate for a situation that you're dealing with, please reach out to us. The final topic I'm going to be speaking about is frustration of contract. And this is a somewhat unique situation in which a termination is actually on the basis of a disability, and it's appropriate in the circumstances. So even where the employee is not guilty of any wrongdoing, they're still being terminated on the basis of their disability. And that's possible because the law considers frustration to be a situation where there's a breakdown in the employment relationship that's so severe and out of both the employee and the employer's control that the employment relationship just simply cannot continue. So typically we see this in a situation where the employee's disability is so severe that a return to work is just not going to be possible in the circumstances. When considering a termination based on frustration, you need to have medical evidence and that really supports the fact that the employee can't return to work. And what ideally we want this medical evidence to say are what I refer to as the magic words. The magic words are that there is no reasonable prospect the employee will be able to return to work in the reasonably foreseeable future. So no reasonable chance this person can come back anytime soon is another way of putting that. Those are the magic words we want to see from a physician. If you've received that clear medical evidence using my magic words or otherwise clearly outlining that there's no reasonable prospect of a return to work, the employment relationship can be terminated due to frustration of contract. Keep in mind that following the termination, the employer must still pay the employee, but it's only their minimum statutory requirements. So in Ontario, for example, the employee is going to get what they're entitled to under the Employment Standards Act, and that's 1 week per year of service, up to a maximum of 8 weeks for termination pay. And if you're a severance paying employee, which means you have a payroll of over 2.5 million, and the employee has been working for over 5 years, that entitles them to severance pay, and that's an additional 1 week per year of service, up to a maximum of 26. So 1 to 8, 1 to 26 if you're severance paying, but that's the minimum legislative requirement. And in a frustration context, that's the maximum you need to pay out during a termination for frustration, following a termination for frustration. What's important to note is that the employee is not entitled to common law notice. I'm sure you've been read the Riot Act between the difference between common law and statutory notice before. So just to be clear, frustration of contract, we're talking about statutory minimums only. And then also, if we're talking in a unionized environment, you'll probably hear the words innocent absenteeism rather than frustration of contract, but it's a very similar analysis that we're talking about. There are also situations where frustration of contract can occur rather quickly. And that's if the severity of the disability makes it immediately and abundantly clear that the employee won't be able to return to work likely ever. And here we're talking about something like a serious debilitating physical injury. That's what might fall into that kind of category where frustration of contract actually happens quick. What's more common is frustration being established after a lengthy time of the employee being away from the workplace. Obviously, the longer an employee is gone, the more reasonable it becomes to think that they might not ever return. All of this, of course, needs to be supported by clear medical that's obtained from the employee's physician that supports whether or not this employee can return to work in the reasonably foreseeable future. And what we often do is we'll provide the employee with a letter to give to their physician that requests confirmation as to whether or not the employee has any reasonable prospect to return. Now, if you've sent that letter and what you get back is medical information that suggests, okay, maybe the employee can return to work, that doesn't mean that your analysis here just ends. What it does is trigger an opportunity for you as the employer to follow up with the employee's doctor and request additional medical that outlines, okay, if the employee can return to work, when is this going to occur? And that sets the stage for a return to work plan and helps develop a paper trail. And it also makes abundantly clear to the employee that the expectation is that, in fact, they are going to be required to return to work. In terms of timing, when you're thinking about reaching out regarding the medical we've just talked about, if the employee is on disability, like LTD, a good time to consider making the request for medical would be when the employee has shifted to the any occupation coverage. And that's because it's around this time that the employee is already providing medical to their insurer. And so these conversations are already happening about what are the prospects of the employee's ability to return to work in any capacity. Okay. So you've heard a lot from us already. We've been talking a lot. We want the opportunity here we want to give you the opportunity here to ask us questions. I know that our colleague has been collecting them throughout. And so I'm going to flip things back over to Priya and she'll get started on that. And thank you again for being here this morning.
Thanks, Chris. So good morning again. I have a list of questions here that have been sent in. I'm going to start working through them in order. I'll take a few and then I'm going to pass it back to Chris to pick up on the second half topic, and then I'll jump in again, but we should have a full half an hour, it looks like. So the first question that I've got is, can we send an employee home with pay if they display unusual behavior until we figure out what the next course of action is? And the short answer is, I mean, yes, if the behavior that you have observed is concerning and you're worried that there's a risk to the business or there's a risk to other employees from a safety perspective, it may be appropriate to send them home with pay. And the next steps will then be to ask them to see their physician to determine if they have a disability that may be impacting on their behavior, and then determine what an accommodation might look like. The second question that I have is, in what industry in Ontario can you actually have a drug testing policy that is upheld? I have a lot of clients in transportation or those going into mining locations, and the mine requires it. So we do get a lot of questions on drug and alcohol testing, and that is likely an entirely separate topic on when drug and alcohol testing is permitted. But generally speaking, it's only permissible in safety-sensitive workplaces or for individuals who work in safety-sensitive positions. So where there is a serious risk to injury to the public or to the employees working there. But even then, I should mention that there are limits on the types of testing that can be performed in these environments. So for example, it's normally considered to be more reasonable to do a test where there has been some evidence of impairment. So if I see you stumbling around in the workplace, or I can smell alcohol in you, that might be a circumstance where it would be reasonable for me to conduct the test, whereas random testing is less permissible. But certainly it's important to have good policies in this regard, and you should feel free to reach out to us at SK if you want to incorporate a drug and alcohol policy into your current employee handbook, for example. The next question I have is it appropriate to ask for a diagnosis if someone has disclosed a substance use disorder? So I'd say here, this is one of the circumstances exactly where a diagnosis would be appropriate, rather than a prognosis for recovery. Okay, I'll take one more and then I'll give it back to you, Chris. Okay, so based on these cases, presumably the cases that I reviewed, The question is it important for medical documentation to have the word disability in it? I would say yes, very important. While they may not have indicated that they have a disability, we can ask for that additional information. That is very much the word that we're looking for, because it is the diagnosis with a disability that, or of a disability that triggers our duty to accommodate as an employer. And if they provide information that supports that they've been diagnosed with a medical condition that's not trivial, it could indicate that there's a disability, even if they don't use that word. But in many circumstances, we're just getting that one-liner saying employees unable to work, and that's just not going to be sufficient. So we're going to want to probe for a little bit more information in that case. Okay, Chris, back to you.
Okay, my first question is, how can stress be a WSIB claim if they can't do their job properly and it's causing them stress when they should be performing at a faster pace? So as discussed, a WSIB stress claim is really sort of an exceptional circumstances. It has to go above and beyond what the typical workplace stress is. So if you've got somebody who's not doing their job properly and they're stressed out, I mean, that's a pretty common thing to be stressed at work. That's a common workplace stressor. We're not talking about something exceptional that goes above and beyond, where the WSIB is actually literally looking at this as a workplace injury. So that type of conduct is not something that's going to be a successful WSIB claim. It's exceptional circumstances only. Next question. You noted that the work situation needs to be the cause of the mental stress injury, despite someone maybe having a previous diagnosis. What if the individual has a previous diagnosis and it's under control and has been under control for a while, but the work situation was the cause of a new trigger that reignited the mental diagnosis? So here, maybe there's a potential for a claim. So I did say that it needs to be the predominant cause of the stress injury. But if there's something that's happened in the past and something very substantial happens in the workplace that triggers it, the employee might still be able to make that WSIB mental stress claim. And that's where you really want to go in that analysis internally as to whether or not is there a sufficient connection here. If there is, they might have a valid claim. What are some examples of a mental stress injury? It could be acute distress disorder, PTSD, adjustment disorder, anxiety or depressive disorder. What's important here is this is not a self-diagnosis by the employee, right? They're not saying, I have a stress disorder because I'm very stressed. They need to have medical evidence that supports this diagnosis. So the categories I just listed could be examples, but it needs to be supported by medical. The employee actually has to be diagnosed with these disorders in order for these things to apply. Can working from home be denied as an accommodation if the company does not allow work from home for anyone? What if the employee requesting an accommodation to work from home was on a PIP and the company wants to deny the accommodation request so that the employee has direct supervision in their office? You can't necessarily totally rely on, everyone's at work policy or work from home accommodation if it can be shown that the accommodation is reasonable. In other words, that the essential duties and functions of the role can be performed at home successfully. So if the accommodation is genuine, the disorder is genuine, and there's medical evidence to back that up, then potentially working from home as a fix, and it could be a reasonable accommodation to apply. That's really tricky. Obviously, in the last few years, we've had a lot of people working from home due to COVID. So where that analysis may be impacted even further is if the employee has demonstrated they were able to successfully do their job from home without issue during COVID. Again, though, we're not talking about preference here. It's not an employee's preference that they get to work from home. That's still you as an employer's discretion. So if it's genuinely tied to a reasonable accommodation, It's a slightly different analysis, but you need medical and you need a doctor's opinion to support that that's an appropriate thing to do. Next question. I'm going to do maybe two more, Priya, and then I'm going to kick things back over to you. So is closing a factory an example of a traumatic event? Well, colloquially, maybe, but that's something that could happen reasonably in the regular context of work, right? A termination is possible for people. Discipline is possible. Not liking your coworkers is possible. That hasn't happened here, of course, but it's possible. So what we're talking about when we're talking about mental stress claims or traumatic stress claims specifically, it has to be something that's beyond just the typical things you see at work. It has to be, I think the language that I used was objectively traumatic. Would a reasonable person see this thing happening and feel traumatized by it? So again, workplace violence, something very serious, a very serious accident at the workplace. That's really what the standard, the threshold that we're considering when we're talking about traumatic events. I'll do one more here. In either of these nurse cases, did the employer allege that the termination was wholly due to breaches of the employee's policies, so the theft, code of ethics, etc., and were unrelated to the alleged disability? So I think certainly the basis for the termination in both cases was the misconduct, right? You take the look objectively at the misconduct, there's theft, there's falsifying of records, and quite frankly, putting patients in danger. Serious misconduct, which in any other circumstance is going to justify a termination for cause. But there's a nuance here, and it's because the employee alleged that in both cases, that their actions were dictated by their addiction. And that, based just on the facts and the evidence, was pretty clear that at least was a reasonable argument. So that's really where the analysis about whether or not the employee was in control of their actions, that's where it arises. So the cause for termination happens, and the union and the employee, both of these cases were in the context of unionized workplaces. The union and the employee are saying, not actually the employee's fault, this is the disability's fault, and they raised evidence accordingly. And then, as we saw in one case, it resulted in the termination being upheld. In the other, the employee was actually reinstated. So I'm going to kick things back to you, Priya.
Thanks, Chris. Okay, so the next question that I have is, do we have a duty to accommodate when an employee doesn't have a disability, but has stress and anxiety due to personal issues? So, I mean, this happens a lot. And the answer is, from a legal perspective, no, there's no duty to accommodate general stress and anxiety if it's not attributable to a diagnosed medical condition. So this kind of goes back to the conversation we were having initially about the distinction between mental health and a mental disability. So we have a duty to accommodate mental disabilities. We do not have a duty to accommodate the general stress and anxiety that might be impacting someone's mental health because, you know, a loved one has passed away or they're getting divorced or whatever it is. As a practical matter, though, as an employer, you may choose to be compassionate and to provide some form of accommodations to an employee, but from a legal perspective, it's not a requirement. The second question that I have is, what if the employee keeps giving doctor's notes for their excessive absences, but the doctor that provides the note is changing every time? Can you ask them to see their family doctor or specify a treating physician must complete a functional a FAF or provide a doctor's note? So normally an employee has the right to see, you know, their whomever they choose as a medical provider. And we would accept their medical notes up to a point. Now, if it looks like, I mean, maybe the employee doesn't even have a regular doctor, but it may be appropriate at some point to ask them to see their regular family doctor, or potentially to see an independent third party to evaluate whether or not they have a disability And this is particularly if we have concerns that the medical information we're not getting is sufficient, or it's inconsistent, or it really doesn't support that they have a disability or that they're entitled to the accommodation that they're seeking. But I would say that initially we'd want to respect the information, the medical information that we're provided with. Okay, the next question is, how should we treat cases where employees provide medical documentation to support their disability and possible need for accommodation that is not supported by a third party assessor? Do we need to engage in an independent medical? So in most cases, if the information is not supported by a third party, you may be in a position where you're going on the basis of that third party assessment if you feel it was completed in a satisfactory manner. So if you trust it, you believe that the information you've been provided with is credible, it's sound, they did a proper assessment. So this is like the how they got to the conclusion appears to be reasonable. It might mean that we, on the basis of that assessment, treat the employee as not having a disability and requiring that they return to work. Okay, so next question. Are employers required to pay an employee for full-time hours if they need to switch to part-time status due to an accommodation? So if the only reasonable accommodation option is to move the individual from a full-time role into a part-time role, or an entirely different role altogether that has a different rate of pay, the duty to accommodate does not require the employer to maintain the prior rate of pay. So if they're working part-time in an accommodated position, you would be paying them part-time. If they're working in a new role at a lower rate of pay, you would pay them the lower rate of pay. Okay, Chris, I'm going to do maybe one or two more and then I'll pass it back to you. Okay. All right. So next question. If there are signs that an employee is is impaired and is sent home without a drug and alcohol test being done, should the employee be paid for the day or not? In the ordinary course, if you're sending them home, that should be with pay. Because we don't actually know what the circumstances are at this point in time, whether their behavior is culpable or non-culpable. Next question, when an employer can't accommodate an employee and the employee has to go on a leave of absence, is the leave of absence paid or unpaid? So if an employee can't work, then the leave of absence would ordinarily be unpaid. But having said that, they may have entitlement to other forms of benefits that would compensate them while they're off. And that could include sick pay, short-term disability, or long-term disability coverage. And as an employer, you would assist the employee in making those applications as necessary. Chris, back to you.
Thank you, Priya. Another question. If an employee is reinstated after being let go for cause, can the employer then fire the employee without cause? So to be really clear, the two nurse cases that I talked about, that was in a unionized context. And in a unionized context, the only way you can terminate is for cause. There is no without cause termination option. And let's just say that we weren't in a unionized context. Regardless of whether you're terminating with or without cause, what you're really looking at here is a situation where there was no doubt that there was misconduct in both of those cases, but it's whether or not the addiction was the driving factor in that misconduct. So you terminate with cause, without cause in a non-unionized environment, what you're really looking at is a human rights claim, whether to the Human Rights Tribunal or as part of a civil claim that alleges that the termination was a form of disability related discrimination. That's what the risk is there. So I hope that answers your question. The next question is how to manage accommodation or relapse if the employee is in a position that requires sobriety to do the job. So a truck driver, or the example given here, a forklift driver. So that's a good question, because obviously the analysis is slightly different there. It's a sobriety and the safety of coworkers and the public, frankly, is tied to the fact that this person is not under the influence of isn't impaired. So this really would be a situation where maybe the last chance agreement comes a little more quickly, or you're implementing requirements early on right away that the employee must abide by to demonstrate that they're not under the influence. So a drug test or a sobriety test before they even get behind the wheel. But that's a good question, because the context there really does matter. Can you use a last chance agreement in a non-unionized environment? Yes, you can. The difference here is it might look a little different because there's no union involvement. When you see it in the unionized context, often you're going to see it where the employee and the union and the employer are all signing this agreement. Here, it's no union, so it looks a little different, but still can be a very effective tool to demonstrate that any breaches of this agreement gets to the point of undue hardship and all the other things you've already done to get to this point. In the case of addiction, where an employee requests a leave to attend a rehabilitation program and it's granted, but they relapse again, how often is the employer obligated to provide a job protected leave? There's no magic number in terms of how many times you need to continue to try to accommodate. It really is a bit of a contextual basis. So we're thinking of things like the level of addiction, the position of the employee, how important they are to the workplace, how hard it would be to replace them. So there's no real magic number, but certainly after one or two or I would say 2 or 3 attempts in typical circumstances, that's maybe when you get to the point of implementing a last chance agreement, because certainly you're not required to have this go on forever. What if the employee refuses to sign a last chance agreement? Well, that's a contextual basis. You as the employer have to determine whether you're willing to live with the risk that this employee just continue to be accommodated and fail that accommodation. How long are you willing to allow that to maintain? And frankly, if you've gotten to the point where a last chance agreement is appropriate in the circumstances, and the employee refuses to sign it, then it almost supports the fact that you've gotten to the point of undue hardship, because the employee, right, is not agreeing to participate in any attempt at your reasonable attempts to accommodate. They don't want to participate in that process, which I think, at least to me, would demonstrate that they're not really taking the matter seriously. And that would really support that you are, in fact, at the point of undue hardship. So if it was challenged, what you would do is raise the fact that they were presented with this as a last chance and refuse to sign it. Priya, just for context, I got 2 more questions here. Do you have any left, or 2 more? Okay. Are employers expected to pay for any rehab or treatment that they require an employee to engage in to return to work? Absent a workplace policy or something that's in the collective bargaining agreement in the unionized context, no, there's no obligation for you as an employer to pay. It's something you might want to consider, but unless it's in writing, there's no legislative requirement that you provide that payment. Last question for me, please define foreseeable future. Is there a legal definition length of time considered to be the foreseeable future? So here's a lawyer's answer for you. There's actually no real definition for foreseeable future. I've called it the magic words, but they don't actually have a definition. So it's really a contextual basis. And what we're really wanting to do is we're putting that to the physician. So we're putting sort of the responsibility on the physician to be able to define when can this employee return to work. I think, it's a contextual basis, and you kind of apply some common sense here. So if the doctor is not able to say that in the foreseeable future the employee can return, then you've got your magic words. If they say maybe in 5 to 10 years, I think you're at the point where that's no longer, that's not the reasonably foreseeable future. So we put it to the doctor, but there's a gray lawyer's answer for you, which means it all depends. So I'll kick it back to Priya.
Thanks, Chris. And actually, I would completely agree with that assessment. Okay, two last questions that I have. One, is an employer required to create a new position for a disability-related accommodation? So no, employers are not required to create new jobs or make work positions or anything like that when they're accommodating an employee. They should be able to still perform something meaningful if they're being accommodated in the workplace. And they should ideally be able to be accommodated in their own role or possibly another existing role if there is one. Let's see. All right. Are you obligated to tell managers and coworkers about someone's disability? This is actually a really good question because there's a delicate nuance here. Obviously, employees have a right to privacy in their medical information, and employers should not be disclosing their private medical information to any of their colleagues. But if there's an accommodation that's going to be impacting other employees, there may need to be some discussion about this. So what I would suggest is that you sit down with the employee who needs to be accommodated and talk to them about how they want to handle the situation. They might want to share information with a colleague or their colleagues themselves first, or maybe, they're comfortable with you letting them know, what's kind of happening and what to expect in the workplace. And this would relate not just to a substance use situation, but other mental illnesses where a person's behavior might have an impact on their coworkers from time to time, for them to understand, if I'm behaving this way or if this happens, please don't take it personally. This is what's going on for me right now. This is how I need you to respond, or this is the best way to respond to me. And sometimes that dialogue with the employee's consent can really mitigate potential issues in the future. But yeah, you wouldn't just disclose it to those colleagues without consent. So those are all of the questions that we have. Chris, did you have any other comments on?
No other comments other than to thank everyone for attending today. We're at the end of the program and we hope that you found it informative. The video and the slide deck will be on our website in about a day or so. If you didn't get a chance to answer your question, we apologize, but please drop us a line and we'll do our best to and we will get back to you as soon as possible. Our next HR review webinar is going to take place on Wednesday, December 6th, 2023. And the topic is still in the design phase. So I'm sure you're on the edge of your seat. If you're on our mailing list, you will receive an invitation. And if you're not, and you want to receive our briefing notes and our newsletters and our invitations to seminars, workshops like this, please subscribe through our website. It's the big red bar that's at the bottom of every page. We'd also be grateful if you'd fill in the feedback form. It's going to pop up on your screen once you close the Zoom webinar. We really appreciate feedback. We apply it and it means a lot to us. So if you have the time, please consider doing that. But thank you for joining us. We hope you all have a great day and we appreciate you being here.